we said that international law has certain subjects. And among those subjects, we have studied states and international organizations. Actually, I have never mentioned individuals. And in most of the sources, it's not mentioned. But when we start studying international criminal law, there you'll see that actually individuals can also be included to this list, but not as a norm. So keep it in mind. But while learning, organizations or states are subjects, and sometimes individuals. We'll come to that. And we were asking the question, okay, states are subjects of international law, but who are states then? And we were trying to clarify who are states because we have some cases like Taiwan, for instance, or Ossetia, Abkhazia. What else? Catalonian case, or Kurdish state, or Daesh. They have named themselves as Islamic State. So are they really state? Should your state get in touch with them, start diplomatic relations? Who's a state? How to decide upon? That's why we were learning statehood. Well, statehood is important in international relations, and it has, first of all, some basic criteria. In order to define those basic criteria, we have two sources. Now you tell me, what are those sources? First of all, the sources.
Vienna Convention and Montevideo.
Montevideo Convention, because you didn't mention the year in the exam, you would have lost some points. Montevideo?
1991.
Nope. No one remembers. It's so late, early. Normally we don't use that old sources.
1930s?
33, thank you, yes. Montevideo Convention of 33, plus another source. Yugoslavia arbitration? 91, thank you. Okay, those are our two sources. And according to those two sources, the basic criteria teaches us that the first element of a state is territory. And the territory defines a certain band of territory. It doesn't indicate the borders, right? You can have, your state can have border problems, and still it can become a state as long as it has a consistent band of territory. So what is consistent band of territory? Having an address, right? And what does it mean, having an address? Either you're giving your address through using elements of nature. Those mountains are north upon our country, and that river is on our east, and that lake or sea is on our south. That's how you define it. Or if you cannot give such details, then you have to be able to define the address of your country through our names, longitudes, and latitudes. This means your address has to be permanent. And this means you cannot build a platform and sail through high seas and say that this is my state. No, you cannot be floating. You have to be permanent on a certain piece, cross piece of Earth. Second element is population, true. And what does it mean?
It doesn't have to be, like, you need people. It doesn't have to be like so many, or like, there's no amount, certain amount.
Good.
Population.
Okay.
You should also exercise your own authority to your people.
So, for population criteria, there is no minimum number, as you have mentioned. But definitely, it has to be permanent. Certain number of people. So, Nauru is a state, Tuvalu is a state, Russia is a state, India, China, and, well, the populations are quite different, but all of them are sovereign states. All of them have a certain permanent population in them. The third basic criteria is about having a government. Is it possible to become a state with a military dictatorship? Yes, 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 of course. With a republic? Yes. How about a monarchy? Yes, definitely. The government indicates actually a very complex network of administration. the state can reach to the depths of the state. It can bring education to all villages even. It can hold registers of population, new births and deaths and so on. So collecting taxes is important, for instance. Holding elections is a complex, it requires a complex network. So this is what is meant by having a government. What's the fourth criteria? No, it's not recognition. The capacity to enter into relations with other states. The same thing. Okay. So this is the fourth criteria. And I disagree a little bit with that. It's an outcome. Actually, first you become a state and then you can enter into international relations with other states. But, well, I mean, I cannot contradict with international treaties. And they tell us that the fourth criteria is either having the capacity to enter into international relations, or the other fourth criteria, everybody has forgotten, sovereignty. Having sovereignty, what does that mean? Yes, please.
Completely independent from your domestic affairs.
That's so correct. Being completely independent. So there is no higher authority than your government. This is what it means actually, having an efficient, effective government. All right? So it's either entering into international relations or sovereignty. Arbitration of Yugoslavia 91 teaches us another thing as well. States can emerge and disappear. That's also an important thing mentioned in that paper. Well, after having the basic criteria for statehood, we have mentioned another right. That's self-determination right. Now you tell me, whose right is that? Self-determination is a right of nations, not states. All right? And self-determination has two dimensions. It has an internal dimension, it has an external dimension. In Turkey, a referendum is held and the political structure has been changed. A presidential system is established instead of the parliamentary one. So Turkish nation has decided to change its system. This is internal self-determination. External self-determination is establishment of Pakistan. What do I mean? It was the process of decolonization. Colonizer powers left India completely. Well, India is still huge, but it was huge. I mean, it was including Pakistan, Nepal, and Bangladesh. And later, those nations, like Muslims of India, they have decided to have their own state, separate state. So they have used their self-determination right to decide upon if to live under the Indian rule or to have their separate state, and they have opted for a separate state. So Pakistan state was established in the 50s for this reason, by using their self-determination right. Self-determination right is a limited right. Do you remember what the limits are?
Cannot conflict with the right of sovereignty of states.
Definitely. It cannot contradict with the sovereignty of other states. What else? It cannot
Cannot contradict with the basic principles or essential principles of civil societies, which we call as Yugoslavian rules.
Nothing can actually, true. Well, Yugoslavians, it's something universal about territory.
It should be happening in a territory that is not controlled by another.
So, it cannot, self-determination cannot happen as secession. It cannot hurt territorial integrity of another state. It cannot damage territorial integrity of another sovereign state. Self-determination can take place if the consent of the central authority is given. What I mean is, like the case of Spain, Spanish government and Spanish constitution, first of all, it does not let for regional referendums for secession. Secondly, Spanish government, Spanish legislation, they have never given consent for secession of Catalonian state. So if they were accepting secession of Catalonia, then Catalonia could become an independent sovereign state. But it has never taken place. How about the case of Scotland? Does anyone remember what was happening in Scotland?
Referendum to break away.
And was that a similar case with Catalonia?
It was legal. The referendum was approved by the central government.
Definitely, and the referendum was held all around, actually. I guess it's going to be repeated this year. Or perhaps, I'm not also quite sure. We have to take a closer look at it.
Like all around UK.
Yes. If I'm not mistaken, let's read about that. But that's what I remember. While self-determination has its limits, territorial integrity, sovereignty of other states, and the consent of central government is necessary, we have said. What else? It can take place during decolonization. It's completely legitimate. Once the colonizer power goes away, then the nations can decide upon their future. I mean, they can decide to live under another state, or they can decide to establish their own state. From that point, we have spoken about the role of Trusteeship Council, and it is inactive at the moment since 1994, if I'm not mistaken. It's inactive. Trusteeship Council is not holding their annual meetings anymore. We have mentioned sui generis states. Yes. Give me some examples. Vatican, Taiwan, North Cyprus. What else? Transnistria. True. Good example. Abkhazia, Ossetia. Well, actually, Abkhazia, Ossetia, true. I mean, only we can discuss about during recognition. I don't know if we can mention them as sui generis states. Actually, yes, there is still. It's like the case of Kurdish state or Catalonia. They have tried, they have found some backing, but they're completely against sovereignty of Georgia. So, well. And then what have we mentioned? Recognition element. Recognition element, the most important thing you have to remember is that recognition, there is nothing in international law that compels, that obliges states to recognize others. This is the first thing. Second thing, recognition decision is completely political, correct? It's completely political. Recognition is a one ballot gun. When X state is mad at Y state, they can pull their ambassadors back, but they don't pull their recognition back. Turkey state has pulled its ambassador from Egypt, from Israel, from, well, numerous states actually, Armenia. But Turkey state has never, okay, we unrecognize Armenia, we unrecognize Egypt, we unrecognize Israel. It does not take place.
Azerbaijan unrecognized.
It is not unrecognition. They already have a territorial dispute. That's why. So recognition is a political decision. Recognition can be done once. Recognition, there is nothing that obliges states for recognition. And recognition is still very important because definitely diplomatic relations can only be initiated by recognition. After recognition, states send their ambassadors to each other. They start their diplomatic relations with each other. So recognition's importance is like in diplomacy. Yes, please.
In some cases, sometimes the states are calling back their ambassador from the country if there's a problem, but it doesn't directly mean that they cancel the recognition.
No, it is not cancellation of recognition. It is downgrading the representation. That's it. All right. We'll study diplomatic law. We'll come to that. Yes, please.
Speaking of recognition, maybe it will be better to differentiate between recognition of states and recognition of governments. Because today in the Venezuelan case, we see that there is nothing problematic with recognition of Venezuela as a
What we mentioned here is directly recognition of the state, so statehood's recognition, not the government's. Okay, good point. So that's how we have defined statehood, roughly. Is there anything that you have missed? Then let's start with international organizations as subjects of international law. Actually, there's a confusion. In the textbooks, the books I have given to you for compulsory reading, it's mentioned as international organizations. What's meant is intergovernmental organizations, all right? Well, those organizations are the basic elements of them. They're international, first of all. And they are non-state entities. But they're established by states. They're not NGOs and not multinational corporations. So first of all, let's clarify what those three things are. Intergovernmental organizations, NGOs, non-governmental organizations, and multinational corporations. Let me ask you a question. Your membership to United Nations. Before I start with membership, give me some examples for NGOs first of all. Greenpeace. Nope, it's an intergovernmental organization. WWF. What else? Red Cross. Red Crescent. What else? Louder, I don't hear you. FEMAN, for instance. Oxfam, for instance. Médecins Sans Frontières, for instance. They're all NGOs. How about FIFA? What's FIFA? Or UEFA? Who are the members of FIFA or UEFA? Oh, come on, don't you?
The federal leaders of the local federations of countries.
Football federations, that's true. So it's not intergovernmental. It's football federations coming together. So it's a kind of NGO. So you know what NGOs are. We have given the example of Amnesty International, Greenpeace, FEMAN, Oxfam, Médecins Sans Frontières, Red Cross, Red Crescent. How about multinational corporations? Give me some examples for them. Coca-Cola, of course. What else? Apple. Mention more, some multinational ones. Well, Nike, Burger King, Microsoft, of course, Audi, right? There are multinational corporations. Now, let's move to your membership. Tell me, can you become a member of UN? Can you become a member of Amnesty International? Can you become a member of Audi?
You have no states become members of the
True. I mean, you and me, we don't personally try to become members of UN. If your government is already, if your state is already a part member to UN, so we don't try to become members. That's clear. How about Apple? Do you become a member of Apple? You become a customer. Or what else can you become?
Shareholder.
You can become a shareholder, of course. But it's not membership. It's something else. And can you personally become a member of Amnesty International? Yes. Yes, definitely. Individuals are members of NGOs. Individuals become members of, it doesn't matter if your country is a party to, I mean, your state does not become part to Greenpeace. States are against NGOs, come on. Somehow. The thing is that individuals become volunteers. So about membership, now you have a common understanding. Let's talk about profits. Who is trying to make most profits? UN or Amnesty International or Apple? Of course, Apple. How about Amnesty International? Are they trying to have the best profits? They're definitely not interested. UN? They have other goals. They're not trying to make money. How about then Amnesty International? If they're not trying to make money, what are they trying to do?
Influence the domestic politics.
Well, NGOs have social goals. They're trying to awaken interest in certain issue areas. They're trying to attract interests in certain issue areas, make campaigns, right? Social awareness. That's what NGOs are, and they're not trying to make best profits. Neither intergovernmental organizations. They have their own issue areas, and they're trying to fulfill their goals. If we're talking about UNHCR, United Nations High Commissioner for Refugees, their goal is protecting and helping asylum seekers and refugees, but not making the best profits. Profit makers are multinational corporations. So when I mentioned that international organizations or intergovernmental organizations as subjects of international law, now you know who I am talking about. I'm not talking about FEMAN, I'm not talking about Coca-Cola, but I'm talking about UN or Interpol. Or, give me some examples for intergovernmental organizations now. EU. What else? Interpol, right. Arab League, African Union, Arab League, NAFTA. So, we have a huge list of intergovernmental organizations. NATO is one of them, Council of Europe, the World Bank, European Union, UN. And we already know that they're not the same. They have some differences, you already feel that. So we have to focus on what the differences are. First of all, we can talk about geographical distinctions. Some of them are global. So we don't have a continent focus. We don't have a regional focus. We have mentioned African Union, for instance. There we talk about a regional international organization. But when we mention UNESCO, when we mention UNHCR, when we mention General Assembly, they're all global organizations. So first of all, we can make a geographical distinction in between regional and global ones. Before I continue, let's first of all clarify that definition of intergovernmental organizations. There's a legally accepted definition for intergovernmental organizations. United Nations, UN, has a branch to interpret international law. It's known as International Law Commission. International Law Commission, from time to time, they publish diverse papers related to different issue areas of international law. And related to intergovernmental organizations, they have published 2 articles of agreement related to 2 articles related to the nature of intergovernmental organizations. It was first done in year 56 and later in 75. They have long names, those papers. You don't need to remember them, but you need to know that the definition of intergovernmental organizations is done by ILC twice in 56 and 75. Then you can find the sources once you need them. According to those sources, we come across with 3 important factors that tell us about intergovernmental organizations. The first one is, all international organizations are established by a treaty. States come together, formulate a treaty, sign it, and ratify it, and as a result, the organization is established. So if you need to study any intergovernmental organization, you have to find, first of all, the founding treaty. And because you have already studied treaty law, you know that the treaty can be one single document or can be composed of multiple documents, can have additional protocols and so on as well. So if you're studying the Security Council, you know that first of all you have to refer to the UN Charter. If you're studying any kind of UN branch, then first source is the UN Charter. Then, for instance, you're studying International Court of Justice. First you refer to UN Charter, and then you refer to the ICJ Statute. So now we're talking about multiple papers. All of them are established by agreements. Secondly, they're governed by international law. What it means is, for instance, all around the world, there are Turkish construction companies. They're active in Ukraine, in Uzbekistan, Tajikistan, in Qatar, in Egypt, Tunisia, they're all around the world. They make contracts. They promise to make a building. And they sign papers with each other. What if at the end the constructor cannot finish the building? Now you cannot answer the question. What you need to do is going back to that contract to see which court is in charge of it. If it's Egyptian court, if it is Turkish court, if British courts are in charge. That's how you find it. But when disputes are arising in international organizations, the source you are going to use is not national laws, it's always international law. This is what it means that international organizations are subject to international law. And the third element is that they have their own separate legal personality. All international organizations established by a treaty, they have their own legal personality. This means they can conclude treaties with each other or with states. They have their own stamps. They have their own representatives to put signatures on agreements. They have their own obligations to fulfill. They have their own rights. All right? So please learn those three elements. And now you have a deeper understanding of those words. Treaty, governed by international law, and they have their own legal personality. Why do we have international organizations? Actually, while studying international relations, what we learn is that through realist perspectives, states are trying to be powerful. States do not share powers with each other. They try to defeat each other. They try to maximize their profits. They try to maximize their power. In international organizations, we see that states transfer a certain portion of their powers to those organizations. Why should states do so? Why states opt for transferring their powers? How would you interpret that?
Because only that way they can achieve what they cannot via bilateral agreements and so. I mean,
You're a realist, right? It's all about the interests. This is their best interests. What else?
Perhaps they want to promote shared values that they can work above interests and
Good.
accommodate a wide perspective.
Since when do we have international organizations? Actually, international organizations have a deep history. I mean, postal organization, sending simple posts, right? Sending an envelope. It's happening in an organization, so it was always somehow there. But they have intensified, as your friend has mentioned, after the Second World War. Well, we have seen two huge destructions, and since then, we're trying to promote multilateralism. States are trying to promote interdependence. States are not tied to each other with singular ties. We're tied to each other with multiple ties. So we have a complex interdependence. It is not that we're having trade relations with EU. We also have a certain portion of population there. Or through Erasmus, we exchange students, right? We have multiple relations and multiple ties with each other. Why is that so? Because it promises peace. That's why. And what kind of an approach says that? Definitely. So we have international organizations means having cooperation in between states. And states are trying to cooperate, especially since the aftermath of the Second World War, in order to promote peace, security. Before making war, they can use dispute settlement methods. They can use the organs of those organizations. Issue areas of those organizations can be anything. Interpol is about police forces, security. NATO is about alliance formation. World Health Organization, health. UNEP, United Nations Environment Program, about environment. High Commissioner for Refugees is about asylum seekers. So issue areas can be anything, but there is one limit. What's that limit?
They should not violate human rights.
Definitely, Jus Cogens principle is still there. There can be an organization, intergovernmental organization, established in order to prevent human trafficking, but there cannot be an international organization to promote human trafficking, having more slaves. No, impossible. That's something against human rights. So the limit is human rights violations. Let's move to membership. Membership to international organizations, that depends upon the nature of the organization. If we're talking about the regional organization, like Gulf Cooperation Council, that's something specific for those states around Persian Gulf, for instance. Arab League is for Arabic states, right? What else? European Union, for European states then. So the membership is exclusive. It's only specific for certain regions or certain aims. In NATO, that's an alliance formation. So can you imagine NATO, Russia's accession to NATO, for instance? I mean, hello? That wouldn't take place. Now you understand what is meant by exclusive and inclusive membership. UN itself, it's an inclusive organization. Any newly emerging state, if Palestine becomes a state, can become a member of UN. Sure, for sure, definitely. Well, sometimes it's happening like that. Certain states, EU for instance, how many states established EU? In the very beginning? 6 states. And at the moment, how many members does the EU? 28, definitely. So there are founding members and there are acceding members. Through accession process, they have become members. According to general principles of international law, all members are equal. Doesn't matter if they are founding members or they're latecomers. The thing is that there are some exceptions to that, we know. Some states are more equal than others. What do I mean with that? In Security Council, there are permanent 5. Only those 5 states can exercise veto powers within UN, but others cannot. So they have some exclusive rights. Or there are certain organizations, especially commercial ones, financial ones, or monetary ones. There's a money pool there. And certain states are adding money to that pool. And the amount is not same. Not all of the states are putting $100. It's something proportional to welfare of that state. So in organizations like the IMF, like World Bank, certain states that make the most contribution have more say than the others. They have qualified voting rights, for instance. So equality is a principle, but you have to keep in mind that there can be some exceptions related to the nature of the organization. Well said that organizations are subjects of international law, just like states. But this doesn't mean that they have the same features. For instance, we have mentioned in this class that international law is quite obsessed in territory. But for organizations, can we mention about territory of UN, territory of World Health Organization? No, organizations do not have their territories. They have branches all around. So we can talk about UN headquarters in New York. We can talk about UN house in Ankara. But it's still Turkish territory, right? Yes. European, don't give that example now. I'll come to that. Okay, EU is something distinct. Well, it is not even direct subject to international law, but regional law. So it's somehow distinct than the others. Well, territory is one exception. Secondly, do we become UN citizens? Do we become World Health Organization citizens? No. Intergovernmental organizations do not have their own population. They don't have their citizenship. And please don't give me the example of EU once again. That's somehow else. Well, organizations also have their own sovereign rights. But those sovereign rights are not equals of state sovereign rights. State sovereign rights are almost unlimited, related to their internal affairs and their, well, foreign relations as well. Here, the sovereignty rights of organizations, in order to see their extent, you have to read the founding treaty. The rights given to those organizations are mentioned by the founding treaties. The extent of the rights is the amount given to them by their founding states through their founding treaty. The role of organizations. What do international organizations do? What's the role of organizations? Typically, we can say that they adjust behaviors of the states. So the state before the organization and the state after the organization, the state behavior is different. What I mean is, our typical example is always environment. That's easy to understand. Before the state becomes a member of climate organization, the factories around the state are polluting the air. The state becomes member of climate organization. After that, behavior of the state changes. The state makes new laws. And then, through those laws, they ask factories to install filters to their chimneys. Then the state starts to inspect those factories. And the state also starts to penalize those factories, if they don't have filters on their chimneys. So the state behavior has changed, right? Before the organization, the state did not care much about polluting the air. After the organization, the state has started to inspect and to install filters. So this is a behavior change, all right? So they influence the behavior of the states. That's the role of intergovernmental organizations. International organizations have their own organs. Like we have mentioned that United Nations, true, they have 6 organs. So they have certain and primary organs. They have secondary organs. What I can tell you that actually they're specific to each organization. The thing is that, for instance, UN has UNGA, UN has Secretariat, and those are typical. Almost in all international organizations, there is one administrative body like Secretariat. There is another body, another organ, a plenary organ like General Assembly, which functions like a forum at least, that all members can come together, discuss issues, do votings, solve problems, whatever. We can also talk about secondary organs, like UNESCO. We have said that among those 6 main organs, we never mention UNESCO. UNESCO is established by one resolution of General Assembly. So you don't find any mentions of UNESCO in UN Charter. It's a secondary organ. We have already mentioned the legal personality. They have their own obligations and rights. And where do you understand the personal? Oh, I just spare this question for the end of the class. Let's just keep it for a while. Let's move to powers. The powers of the organization can again be derived through the founding treaty, because all organizations have different powers. But in the most general sense, what we know is that all intergovernmental organizations can conclude treaties with each other or with other states. So concluding treaties is one of the most important powers of intergovernmental organizations. The powers of the organization are determined by the founding members in the founding treaty. And the powers are used in order to fulfill the common interests. All organizations have either one goal to reach or they're trying to prevent something happening. For instance, either they're trying to prevent climate change or they're trying to reach at peace, global peace, regional trade. So they either have a goal to reach or they're trying to prevent something. And the powers are adjusted according to those aims. Each time you hear the word responsibility in this class, in this very class, in international law, what you have to understand is that someone gives harm to another one, injures, damages, hurts, and it has to compensate it, improve the situation, make it fine once again. Try to reverse the situation. This is responsibility, okay? Once a state, we will study state responsibility altogether. Once one state gives harm to another on purpose or it's an accident, they try to compensate it. They try to improve the situation. Organizations have also responsibility. If they damage, if they give harm, if they kill, if they injure others, then they are responsible for their actions and they're supposed to correct what they have done. All right? Did you understand what I mean by responsibility? So responsibility in this class is directly related to legally wrongful acts. One state does a legally wrongful act and has to correct it.